Hey folks, what's going on? This is the voice of Courtney Rollins here with a special podcast. Just actually received a cool question from a person from YouTube, Miss MB. I'll say her name just for privacy and all that good stuff. But Miss MB asked, what happens after inventory is filed in North Carolina? After you, as the personal representative, which is the executor if there's a last will or testament, or the administrator if there isn't a will or testament and someone passes away with assets in their name or debt in their name, they're going to have to go through the probate process, and the personal representative has a fiduciary responsibility to make sure that they're managing the estate. And so part of the process is actually, notifying the court office that there is an estate that needs to be open or a probate that needs to be open. And then you'll receive your letters of administration if you're an administrator, or letters of testament if you are an executor, to be able to manage the estate. That next stage is to send out notice to creditors. You have to file it following the rules and regulations and stipulations of North Carolina, and giving your everyone who maybe has a claim against the estate the opportunity to present that claim based on the timeline that's presented. Go check out other videos we have about those phases, how to notice to creditors, how to open the estate. And if you need more assistance or help, feel free to reach out, just as Ms. MB did. But her question is, what happens after that? What happens once the inventory is completed? So let's take a look. So what's next? Now, the next phase, once the inventory is completed, and by inventory we mean listing all assets, anything in the estate's name, in the person of the decedent's name, needs to be documented. Every single percentage that they're owned, the value at the time of the death. And at this stage, you should be receiving claims from creditors because you've already put in the notice to creditors. And please note, at this point, you are not obligated to make those payments at this point. You will be obligated to, to settle them and to address them, but make sure that in this stage, I would highly recommend that you open up an account, a bank checking account in the estate's name. With your letter of testament or letter of administration, you will be able to do that. And this will give you the chance to have everything in one space, so that the filing and the accounting, which has to take place near the end, is a lot easier then. And so when you start receiving these claims, also please note, folks, that everything is negotiable in life. So you don't have to pay the full amount always. Well, you will if it's a valid claim, but you can call the creditors, let them know that you're the representative, and let them know that you want to be able to work with them. Is there a way to either release the funds? I would ask, just release it and don't have to pay anything, or have it reduced. And you will be surprised at how much you can get reduced or even released. I just recently was able to help with a person get a $248,000 Medicaid lien reduced or removed from their mother's estate, which greatly helped them, because now the funds won't be eaten up by the creditors. So make sure you negotiate with your creditors. You also need to go ahead and file for taxes on any new income that's coming in since the person has passed away or that came in that year. So I would definitely recommend that you connect with a tax preparer for this case. And even all this, I highly recommend that you connect with an attorney. I'm not an attorney or a financial advisor, and but I am sharing my opinions and my experience, and can help you connect with folks. That's my job. My job is relationships, and build and connect with amazing estate professionals across the nation, but particularly in North Carolina. So we'll be able to put you in the right direction. And even so, though, with the attorney and with the tax preparers, there's still going to be a lot of work, as you notice, or as you've seen, if you're in the stage, that you'll have to do. And that's where we can come in and help you. Now, if there's not enough money in the estate to make these payments, you may need to sell property or assets that are in the estate to be able to satisfy valid credits and claims. That's usually where we come in, where we offer a very convenient solution to one of the biggest assets most folks have is real property, is a house, is a home, and we're able to at least give you an option where you can receive money so that your either inheritors can receive their funds quicker, or again, you can pay off some of these, off the debts in an efficient manner. So definitely, if you are interested in learning more about our home buying process, definitely reach out to us, Estate Pro Service. All right. And if there's still insufficient funds, then the North Carolina General Statutes outline the order of priority of who has to be paid and when and where, but you won't have to pull out any of your personal funds. This will have to come from, will need to come from the estate to satisfy the needs. And then you also, again, need to file the tax return as noted. Now, distribution in this phase, this is where folks, this may have taken place prior, depending on the nature of the estate, the size of the estate, but quite often after the debts have been paid, then you use the last will and testament to distribute the funds, inheritance, set up trust, whatever the last wishes were based on that. If there isn't a last will or testament, then North Carolina state succession laws do come into play, and folks' assets or funds are distributed based on that. Now, make sure you keep a detailed record, because the clerk's office will be reviewing and approving all accounting, and any beneficiary will need to sign a receipt and a release acknowledging that they received the distribution. This is going to relieve you as the personal representative of any liability. All right. You're almost done, folks. Closing the estate. Now it's time to go in and let them know, hey, I did everything I need to do. Please release me from this responsibility. The court will take a look at the petition. They'll approve it based on if it's, if it's approved, and you're released from your liability. If there was a bond on there, the bond will be released at that time. And you also receive letters so that you can notify folks like Internal Revenue Services that you are officially done with that capacity. Now, again, if you need help, oh, my camera's not on. Ooh. If you need support or help, hey, here I am. Definitely reach out to Estate Pro Service. Love to work with you, help you. You can sign up to our link up there on our website, estateproservice.com, for a free consultation. Really, I don't charge for my service. Just to be quite transparent, which is where I am. The way I actually keep the lights on is when there is real estate involved. And if the option is valid, or it makes sense, then I purchase the property quick and convenient. And if there's not real estate involved, then it's just my opportunity to help, to serve, to put you in the right direction. And that always comes back. It always comes back. The go-giver mentality is definitely something that we push for over here. And it's served me well and makes me feel, good to be able to get that helper's high. Regardless, hope this message, Miss MB, hope this video was helpful. Definitely hope we get to sit down and chat and learn more about the situation and see how we may be able to support and help you. And hope that you also found this helpful, whoever this you are watching this. Love you. Hit a like, subscribe, share a comment, share this with folks. Yeah, that would mean a lot. All right, rising tides, it lifts all sails.